go ahead and tell us, because we hear in that report, some officials, they're saying they're not sure that those who came there were from EFCC. So what's your impression of what is going on, especially from the court having written that no court can stop the prosecution of the former governor?
Well, what happened yesterday was very unfortunate. And I'm very, very confident that the matter will be properly handled in line with the provisions of the law. I think about June or July last year, there was a clash between the officials of the EFCC and the State Security Service on Awolowo Road in Ikoyi, Lagos. And the Bola Tinubu administration made it clear that such clashes will not be allowed under this administration. I think what happened yesterday, the government will have to come out very clearly and make the point abundantly clear that the rule of law has to operate in Nigeria. And once a government has fidelity to the rule of law, police officers, state security officers cannot prevent the EFCC from carrying out its statutory functions, more so when a trial court had given that body a warrant to bring a suspect to court because a charge had been filed alleging the theft of over 80 billion naira. So it is in the interest of ex-governor Yahaya Bello to rush to court and defend his name. But once your immunity has expired as a governor, you cannot go to a court and have it extended indefinitely. That is the position of our law. The Supreme Court has made it clear that a federal high court cannot be prevented by state high court from trying a citizen because both courts have coordinate jurisdiction. So, in other words, Mr. Yahaya Bello's lawyer cannot go to the federal high court and say, our client will not come because there is an order of a Kogi State High Court that he should not be arrested or prosecuted. No. The Supreme Court made this point in the case of ex-governor Jikalu and the EFCC. In the case of Uwazorike and the FRN, that the order of a court of coordinate jurisdiction cannot prevent a trial court from putting any citizen on trial. Once a charge has been filed in the appropriate court, you cannot say you are not going to court. Or higher security officials to prevent either the EFCC or the police or any other agency from carrying out functions, statutory function.
All right, so having said that, isn't the procedure such that, because some of those in the report, the officials of the Kogi State government were saying they are not sure if they are from EFCC because there's a court judgment. So, yes, we heard what you said, but are they not supposed to vacate that order and then proceed, or are they supposed to disregard it and proceed with the arrest and prosecution of the former governor?
Chamberlain, once a criminal court has ordered the arrest of any citizen or that any citizen be brought before it, if you have any objection to that order, you have to go to that court and say why you are not going to come. But you cannot hire people to prevent the enforcement of a valid and subsisting order of a court in Nigeria. Because the danger is that we are, we're having a policy that permits two types of legal systems, criminal justice systems, one for the poor and one for the rich. And that is against the provisions of the Nigerian Constitution.
So,
I'm just looking at the pictures once more, and oftentimes we've been told that officials of the EFCC are drawn from the rank and file of the Nigeria police. Interestingly, yesterday the Nigeria police were the people involved in actually stopping the effect of this arrest. What do you think should be, what conversation should be happening in this regard?
Well, I strongly believe that the Inspector General of Police will have to take certain actions. The first is that all the police officers involved in the macabre dance yesterday will have to be recalled and charged with obstruction of justice, because that was what happened yesterday. And no security officer in Nigeria has the power to frustrate the EFCC or any other lawful agency from performing its statutory functions. The Supreme Court has made the point that nobody in Nigeria, apart from the president and sitting governors, the sitting president and governors, that enjoy immunity, any other citizen cannot be shielded by the police from prosecution. That is the law.
But this is not the first time.
Otherwise, we are violating the Constitution by shielding certain suspects from going to court to defend themselves, while other citizens are being railroaded to jail via the courts. You cannot be allowed. So I will expect the Inspector General of Police to ensure that the order of the Federal High Court that Mr. Bello Yahaya be brought to the court for arraignment is carried out. Otherwise, it is going to be a dangerous precedent whereby terror suspects, armed robbery suspects, and go to court and say, I don't want to be tried. And you hire security people or thugs to prevent the EFCC or even the police from carrying out their statutory duties.
Last time we've seen this sort of injunctions being received by people who once occupied office. There's always been that famous perpetual injunction which was obtained by former governor of Rivers State, which it's unclear if the EFCC ever obtained something to vacate that particular injunction, but that seemed to have set a precedence for what we now began to see much later by other people trying to get, court injunctions, prevent themselves from being arrested. How dangerous a precedent do you think that really set for us?
Frankly speaking, it is tantamount to judicial rascality for judges in Nigeria
Mr. Falana, I'm afraid you're muted. Mr. Falana, if you can hear me, you're muted. Kindly unmute, please.
What will have to happen here?
Thank you.
From the information at my disposal, one of the NGOs, one of the civil liberty organizations, has decided to petition the National Judicial Council in respect of this matter, because we can't go on like this, whereby a court will say, the case in Kogi is a civil case. The case before the federal court in Abuja is a criminal case. And what the court is saying, what the Supreme Court is saying, is that yes, you have the right to have your fundamental rights respected. But once there is reasonable suspicion that an offense has been committed by virtue of Section 35 of the Constitution, you can be arrested and brought to court. So I believe that this should be the last time that this embarrassing situation will be allowed in this country. The government that has ordered, this government has directed all security agencies in the country to stop this type of clash, because it is unwarranted. It is unnecessary. You are asked to protect a former governor or a sitting governor, not to frustrate an agency of the government like the EFCC from performing its own functions. That is the position. So that is why we must.
Yeah, the other
Nigerian lawyers, the Nigerian Bar Association, the NJC will have to rise to the occasion, so that our country will not be further exposed to ridicule. So before the Committee of Nations.
The other aspect is,
as it is the case now,
when you talk about obstruction of justice, the role that the current governor of Kogi State played, because there were images that suggested that he got in there. I mean, I think the statement from the commission too said they spirited the governor out of the premises, and as such, they frowned at any obstruction. The role that the Kogi governor played, was he obstructing justice and his immunity cannot be waived? So what happens in that area, in that regard?
As far as this matter is concerned, a charge is pending in the Federal High Court. The court has made an order that Mr. Yahaya Bello be brought to court. I am very confident that the court will insist that the suspect be arraigned in court. And if his lawyers, if Mr. Bello has any objection to that order, he is perfectly in order to approach the Federal High Court and to convince the court why it should not be tried for allegedly diverting the sum of 80 billion naira from the coffers of a poor state like Kogi. This is a very simple and straightforward matter. He ran away yesterday, but he cannot run away forever.
I'm not sure that the question has been answered, Mr. Falana. The question of, I don't know if you can hear me, Mr. Falana. The question of whether or not, what happens to the sitting governor if indeed he was the one that took the former governor out of his residence for him to avoid the arrest by the EFCC? What happens to that particular individual?
Well, because the sitting governor currently enjoys immunity under the Constitution, not much can be done to him for now. But again, I'm taking a dominant part in the obstruction of justice that occurred in Abuja yesterday. There is no statute of limitation with respect to that offense. The EFCC will have to conduct an investigation as regards what happened yesterday. And at the appropriate time, the sitting governor, once he loses his immunity, and be charged. But as I've said, he used certain agents who do not enjoy immunity, unfortunately for them. All the security officers involved in colluding, all the security officers that colluded with the sitting governor to prevent the EFCC from arresting a criminal suspect can be charged right away with obstruction of justice so that this ugly incident will not repeat itself.
Well, one of the challenges that one might also raise from there is the kind of communication that has gone out about this particular matter. As you said, on the one hand, it's a civil case. On the other hand, is a criminal case. And there are some of those people at the venue yesterday, at that house yesterday, saying that the EFCC was overruling or overturning a court decision when it went and besieged the house of the former governor right there. Of course, many of them knew of a subsisting order, but they didn't know the circumstances of both. And of course, whatever rhetoric is put out is what people go with. Now, in that light, what should the communication be going forward? And who should be putting this out so that people have a good understanding of the circumstances around this particular case?
Okay. What happened here was that the former governor approached the Kogi State High Court that my fundamental right to liberty should not be tampered with by the EFCC. No court, and the court in Kogi could not have said that if there is reasonable suspicion that an offense has been committed, the suspect should not be charged. Now, EFCC went to that house armed with an order of the Federal High Court, which is pending, which is subsisting, valid order. The EFCC was directed by the Federal High Court, go and bring the suspect for the purpose of his arraignment. Again, you will recall last year, when a former governor, I think Governor Okorocha, resisted arrest, the EFCC broke into the house in line with the provisions of the Administration of Criminal Justice Act and took him out and arraigned him in court. I am very, very confident that in this case, once the EFCC has been directed by the Federal High Court to bring Mr. Bello to court, that order, unless it is vacated, either by the Federal High Court or the Court of Appeal, the order will have to be complied with. And I'm saying, in not less than 10 cases, the Court of Appeal and the Supreme Court dealt with this situation, and all the decisions are to the effect that no court can turn any citizen into an outlaw. In fact, the court is saying, how dare you to come to court and say, I don't want to be prosecuted, if there is reasonable suspicion that an offense has been committed. In this case, a charge has been filed in court alleging the criminal diversion of over 80 billion naira. That charge is pending, and the court has said, on this charge, and the processes are attached, I am ordering you to go and bring this suspect for arraignment. Okay. So,
just a quick one.
For any high court,
yes,
to disregard the judgments of the Supreme Court and the Court of Appeal on this matter, it's a very serious matter that will have to be dealt with. Otherwise,
now that brings to the issue. Well, what should be the SOP? What should be the MO for that kind of situation? On the one hand, we have orderlies with the former governor. We have orderlies, security details with the governor. And we have security details, of course, who came to enforce a court order. What are the dynamics there? Because at the end of the day, it seems like we're just putting these guys, the security agents, at loggerheads. They are there, each one of them, to do their jobs. So what should be the MO here? For the one hand, the orderlies with the former governor, the security detail of the governor, and the security agencies who came to effect a court order.
Well, for me, I think the leadership of the EFCC must be commended for restraining its officers from employing force to carry out the order of the court. It will have been in order. There was an incident in America where a criminal suspect resisted arrest. The security agency set fire on the house. Yes. And of course, the criminal had to run out and was arrested. In Nigeria, under the Administration of Criminal Justice Act, once a criminal suspect is straight to a house, security agencies, even the police and others, are empowered by law to invade the house and bring him out, take him to court. In this case, the officers that colluded with the sitting governor to prevent the arrest of Mr. Yahaya Bello, as I said earlier, have committed an offense. It is called obstruction of justice. Those officers are liable to be arrested and prosecuted. And that has to be done so that the security agencies in Nigeria will know that we are not operating in a banana republic. This is a country that loudly proclaims to operate under the rule of law. There's no provision for this type of rascality that occurred yesterday. Again, as I said, the EFCC deserves commendation for not engaging in a physical combat with the police officers that prevented the arrest. Otherwise, it will have been a different matter entirely.